Okay, guys, welcome back to another edition of Lawyered Up. I know we just had one yesterday, but if you tuned in yesterday, you saw that at the start we had a comment about a decision that was coming from Henryetta MCN versus Henryetta that I hadn't seen yet. So today I went and pulled those documents and read them, and the opinion and order here is great, and I wanted to read some sections from it. Before I get into it, though, I wanted to apologize to the guys from Decolonize Decatur, because I know we were going to have them on today, and I had to bump them to do this, but we're going to reschedule with them and talk to them in the future. So that's still going to happen. We're just going to have to reschedule it because I wanted to get this in and let you guys know, because I know the audience here is going to love this. So a little backstory on the case. This case was filed by Attorney General Jerry Wisner July 8th, 2025. And basically, and by the way, guys, links to both the original complaint and this opinion and order are in the description of this video if you want to read them. Basically, the complaint was that after the McGirt decision, A.G. Wisner had learned that the City of Henryetta was still prosecuting natives for municipal crimes in their jurisdiction. She contacted the city attorney of Henryetta and basically was told, we're not going to recognize the McGirt decision. We're going to keep prosecuting Native Americans, and that's what we're going to do. And so this case was filed. The decision here, or it's not, it's opinion and order granting preliminary injunction. Okay, I don't know what happened there. That was weird. I don't know if you guys caught that. There was a kind of an interruption. The stream went down. So I'm just going to keep going with that. It's showing green right now for me. If you guys have any troubles or you lose audio or something in the post in the chat, I'm going to jump back in where I was. The preliminary injunction is to stop Henryetta from prosecuting Native Americans that are on the Creek Reservation for municipal crimes and state crimes. I wanted to read some big chunks here out of the order and opinion because it's really good, and it touches on all the aspects of different arguments, including O'Brien and other stuff. And so I'm just going to jump into that, and you guys, if you have any questions or anything, pop them in the chat, and we'll work on through this. So let's take a look at it already. So this is the United States District Court, Eastern District of Oklahoma. This is U.S. Magistrate Judge Jason A. Robertson is the author of this. It's opinion and order granting preliminary injunction. And I love how this starts. Let me move this over a little bit. So this starts out, sovereignty is not a matter of preference. It is a matter of law. This case does not require the court to break new ground. It requires the court to hold the line. In its order denying the city's motion to dismiss, the court held that Ute Indian Tribe of Unitah and Ouray Reservation versus State of Utah, McGirt v. Oklahoma, and Hooper v. City of Tulsa leave no room for municipal prosecutions of Indians in Indian country absent congressional authorization. That holding controls. This order enforces it. Jurisdiction does not arise because a municipality asserts it. Sovereignty does not yield to repetition. The constitutional boundaries of sovereignty are not optional. They are fixed by the Constitution, defined by Congress, and confirmed by the Supreme Court. This court's duty is to honor them. That conclusion rests on settled federal law. For decades, states and their political subdivisions have lacked criminal jurisdiction over Indians in, quote, Indian country, end quote, absent congressional authorization. McGirt v. Oklahoma The rule is neither novel nor unsettled. It has been affirmed repeatedly by the 10th Circuit and the Supreme Court. This court does not reopen that framework. It applies it as defined by Congress and the Supreme Court. This case concerns a constitutional promise. The rule of law, not the rule of preference, governs the reach of every government within the United States. When Congress speaks with clarity, its voice is supreme. When the Supreme Court interprets that command, its word is binding. When a municipality, however well-intentioned, claims authority that Congress never gave, that claim fails. It also reflects a constitutional commitment. The treaties between the United States and the Muscogee Creek Nation are not relics of history. They are living agreements, ratified by the Senate and protected by the Constitution. Article 6 makes those treaties the supreme law of the land. That commitment did not expire with time, statehood, or convenience. Enforcing it today is not an act of politics or preference. It is an act of fidelity to this nation's word. The Muscogee Creek Nation seeks not favor, but enforcement of treaties solemnly ratified, statutes deliberately enacted, and decisions lawfully pronounced. The City of Henryetta opposes, asserting jurisdiction contrary to those authorities and invoking a theory of concurrent power the Constitution has never recognized. The question is narrow: whether any municipal subdivision of Oklahoma may prosecute an Indian, whether member or non-member, for conduct occurring within Indian country absent explicit congressional authorization. That question was settled long before McGirt. McGirt did not create the rule, it enforced it. Yet Henrietta persists, relying on a state court decision, City of Tulsa v. O'Brien, to assert concurrent municipal jurisdiction over Indians within the Creek Reservation. That claim cannot survive the Supremacy Clause. Article 6 declares that federal treaties, statutes, and controlling Supreme Court precedent are the supreme law of the land. When federal and state law conflict, state law yields. The record before the court is extensive. Over 250 pages of live testimony and argument were taken on October 7, 2025. The witnesses included the nation's Secretary Zachariah Harjo, Chief Richard Phillips of the Light Horse Police, Chief of Police of the City of Coweta Michael Bell, Deputy Attorney General Geraldine Weisner, Court Administrator Kevin Dillinger, and for the city, Police Chief Stephen Norman and City Attorney John Insabella. The testimony at hearing established that the Muscogee Creek Nation maintains a fully funded, professionally staffed justice system recognized by 64 jurisdictions across its reservation. The City of Henrietta stands nearly alone in declining partnership with the nation. Its attorney identifies no congressional authorization. Its police chief identifies no credible public safety breakdown attributable to jurisdictional limits. Every witness testified candidly. Every witness left the legal question untouched. No one pointed to an act of Congress granting the city criminal jurisdiction over Indians within the Creek Reservation. That silence is more telling than any asserted need for concurrent authority. As the 10th Circuit made clear in Ute, invasion of tribal sovereignty can constitute irreparable injury. The Supreme Court held that Congress promised the Creek Reservation would endure in perpetuity, and that Congress never clearly withdrew that promise. This order does not create new law. It enforces old promises. It reaffirms that within the geographic boundaries of the Creek Nation, the Constitution, federal statutes and treaties govern jurisdiction, not municipal preference, not state expedience, and not political convenience. Okay, I just want to pop in for a second because it's a banger, guys. I'm just taking a look at the chat here. Sets the stage for a SCOTUS. Yeah, states are subordinate sovereigns under tribes in pecking order and on totem pole. I agree with you there, TY. So this is a long order. I'm going to skip down here because the next part, let me switch back, is the findings of fact. And most of this stuff, you guys, we will already have, Creek Nation, the federally recognized tribe, etc. I'm going to skip down here, though, because there are some findings of fact I wanted to point out here. Let me just go down. I believe it's 32. So findings of fact are like the judge is saying that this is a fact, right? 32 here you see is, following McGirt, the City of Henryetta issued citations and prosecutes both Muscogee Creek citizens and non-member Indians within the reservation and intends to continue to do so. Okay, so that's the judge saying in his opinion they proved that was happening. And then the next one I wanted to read was 37. The city attorney stated in his declaration that the city intends to continue prosecuting non-member Indians and that its asserted authority rests on its interpretation of O'Brien, McGirt, and Oklahoma v. Castro Huerta, not on any identified act of Congress. Okay, so I'm going to skip ahead here. Hold on just a second. Let me bring my pages back. Because now that the judge is going to outline, what a preliminary injunction, etc. is, I wanted to skip down a couple pages here and start on this analysis. Likelihood of success on the merits. The nation is likely to succeed on the merits because Congress, not Oklahoma or its municipalities, defines criminal jurisdiction in Indian country. Taken together, those decisions establish that absent clear congressional authorization, neither Oklahoma nor its political subdivisions may prosecute Indians for conduct committed within reservation boundaries. The city identifies no such authorization because none exists. City Attorney John Insabella testified that the city's assertion of jurisdiction rests on its interpretation of O'Brien and not on any identified statute or act of Congress. This rule did not begin with McGirt. For more than half a century, the Supreme Court has held that once Congress establishes a reservation, it remains intact until Congress clearly says otherwise. Historical practice, population shifts, and local custom cannot substitute for congressional action, nor did allotment or the transfer of individual parcels dissolve reservation status. McGirt did not create these principles, it enforced them. Nor did this principle originate with the Major Crimes Act. McGirt itself traced the doctrine to Ex parte Crow Dog, where the Supreme Court recognized that criminal jurisdiction over Indians in Indian country had, from the beginning, been governed by federal treaties, statutes, and the political branches, not by unilateral assertions of state authority. McGirt did not create that rule. It reaffirmed a principle the Supreme Court has recognized for more than a century. The same rule appears outside the Major Crimes Act context. In Hagan v. Utah, the Supreme Court again recognized that Congress has not granted criminal jurisdiction to Utah to try crimes committed by Indians in Indian country. The rule limiting state criminal jurisdiction over Indians is not offense-specific. It is structural. The record further establishes that multiple municipalities within the reservation operate under cross-deputization agreements with the nation, allowing officers to respond to incidents involving Indian and non-Indian suspects and refer cases to the appropriate prosecuting authority. These facts undermine the city's claim that jurisdictional limits prevent effective law enforcement. Henrietta's refusal to enter the same agreements available to other municipalities reflects a policy choice, not a legal necessity. Policy cannot create authority Congress never gave. The question before this court is whether any municipal subdivision of Oklahoma may lawfully prosecute an Indian for conduct occurring within the Creek Reservation. The answer is found not in speculation, but in statute, treaty, and binding precedent. This case is governed by a single rule. In Indian country, criminal jurisdiction over Indians exists only where Congress has affirmatively conferred it. Absent that grant, it does not. The rule does not turn on tribal membership. The absence of congressional authorization applies to Indians in Indian country, member and non-member alike. So then they talk a little bit about the Congress alone defines jurisdiction in Indian country, but I wanted to skip down here a little bit because the next part I wanted to read was on page 17. And I believe it is, where does it start? Yes. The Supreme Court has reaffirmed that Congress's power to legislate with respect to Indian affairs is plenary and exclusive, derived from the Constitution's text and structure, and that when Congress acts within that sphere, state sovereignty yields. Holland versus Brackeen. Congress alone defines the jurisdictional line in Indian country. When it has not extended state power, no municipality may conjure it. The 10th Amendment is residual, not generative. It reserves powers, not delegated. Indian affairs were delegated to Congress through the Indian Commerce Clause. The 10th Amendment cannot reclaim what the Constitution expressly gave away. Where Congress has spoken, the states must listen. Where Congress has been silent, they must stand aside. The Constitution's silence here is not an opening, it is a boundary. The city's reliance on Castro Huerta is misplaced. Some have read Castro Huerta to expand state power further. That reading finds no support in the text, history, or decisions of the Supreme Court or this circuit. Henryetta relies on Castro Huerta as if it rewrote the jurisdictional rule. It did not. It answered a narrow question and nothing more. Castro Huerta arose from a single circumstance: whether a state may prosecute a non-Indian defendant for a crime committed against an Indian in Indian country. The Supreme Court held that, in that limited setting, the state and the federal government may exercise concurrent jurisdiction. The opinion was deliberate in its boundaries. The court repeatedly framed the case as involving a non-Indian defendant, and it expressly declined to address the opposite question. Quote, "This case does not involve the converse situation of a state's prosecution of crimes committed by an Indian. We express no view on state jurisdiction over a criminal case of that kind," end quote. That limitation is not incidental. It is controlling. That limitation reflects the very authorities Castro Huerta relied upon, each involving crimes committed by or against non-Indians, not Indian defendants. What Castro Huerta decided for non-Indian defendants is the only question it answered. What it expressly reserved remains governed by existing law. Silence is not expansion. A decision that declines to reach a question does not invite a lower court to answer it. The Supreme Court has recently cautioned that when one of its decisions employs unusually explicit and aggressively limiting language, Lower courts may not extend that decision beyond the precise question presented. Castro Huerta does exactly that. It repeatedly confines its holding to non-Indian defendants and expressly disclaims any view regarding state prosecution of Indian defendants. Henryetta asked this court to do precisely what Shin forbids: extend a Supreme Court holding beyond a question the court expressly declined to answer. What the Supreme Court expressly reserved, this court will not infer by extension. Henrietta's reliance on the General Crimes Act fares no better. The General Crimes Act extends certain federal enclave crimes into Indian country and addresses the relationship between federal and tribal criminal jurisdiction. It does not affirmatively confer criminal jurisdiction upon the states, much less upon municipal subdivisions. Castro Huerta recognized concurrent federal and state jurisdiction only in the narrow circumstance of a non-Indian defendant committing a crime against an Indian victim. Nothing in Section 1152 purports to authorize state or municipal prosecution of Indian defendants in Indian country, and nothing in Castro Huerta held otherwise. To treat the General Crimes Act as an affirmative grant of municipal criminal authority would not interpret federal law. It would expand it beyond both its text and its holding. Nor does the opinion disturb the settled rule this court has already applied. Binding precedent establishes that states lack criminal jurisdiction over Indians in Indian country absent congressional authorization. That rule predates McGirt, was reaffirmed in McGirt, and was left untouched by Castro Huerta. Henrietta's argument depends on collapsing that distinction. It cannot. The city points to the court's statement that, quote, Indian country is part of the state, not separate from the state. And that, I lost my place. And that unless preempted, states have jurisdiction over crimes committed in Indian country. While Castro Huerta emphasized that states do not require congressional authorization to exercise their general sovereign authority, that principle does not extend to criminal jurisdiction over Indians in Indian country. That general language does not displace the court's express reservation of the Indian defendant question. Castro Huerta addressed jurisdiction over a non-Indian defendant. It did not transform territorial presence into jurisdiction over Indian persons. The state's general territorial authority does not extend to criminal jurisdiction over Indians in Indian country absent congressional authorization. Henrietta's reading also confuses territorial sovereignty with criminal jurisdiction over Indian persons. States unquestionably retain sovereign authority over their territory, including reservation land within state boundaries. Sorry, I'm just checking something really quick, guys. Okay, everything looks like it's still good. Where was I? I think I was going to skip ahead here. Finally, Henrietta's reading would invert the structure the Supreme Court preserved. Castro Huerta did not overrule prior precedent, and it did not expand state authority beyond the narrow circumstance before it. To read it otherwise is not interpretation, it is revision. This court does not extend decisions beyond their holdings. It applies them as written. Castro Huerta speaks to non-Indian defendants and no one else. That is where it begins. That is where it ends. To the extent Henrietta interprets Castro Huerta as a license for local enforcement, that interpretation conflicts with McGirt and Ute and is therefore foreclosed by controlling Supreme Court and Tenth Circuit precedent. Now he's going to talk about O'Brien. O'Brien cannot override federal law. The city leans heavily on O'Brien, but that case cannot bear the weight placed upon it. O'Brien may bind Oklahoma courts on matters of state law. It does not control this court's interpretation of federal jurisdiction under Article 6. It is a state court decision that extends federal law beyond its bounds in an area neither entrusted to it nor left ambiguous. The Oklahoma Court of Criminal Appeals took what the Supreme Court declined to decide in Castro Huerta, whether a state may prosecute an Indian defendant, and declared an answer of its own making. That answer extends beyond the Supreme Court's holding. The Supreme Court's holding was confined to crimes committed by non-Indians against Indians in Indian country. O'Brien extended that reasoning to the opposite circumstance, and in doing so extends federal law beyond the jurisdictional boundaries Congress has defined. O'Brien reaches its conclusion by extending Castro Huerta beyond its holding. However, a decision that expressly confines itself to non-Indian defendants cannot be transformed into authority over Indian defendants by inference. The Supreme Court's silence on that question is not a gap for lower courts to fill. It is a boundary they must respect. The 10th Circuit has already spoken where O'Brien went silent. In Hooper, the court reaffirmed that Section 14 of the Curtis Act no longer grants municipal jurisdiction over Indian defendants. Even if the state possessed the authority O'Brien assumes, a municipality could not exceed it. Municipal courts exercise only derivative authority. They do not create it. If the state lacks jurisdiction over Indians in Indian country, its political subdivisions necessarily lack it as well. That holding binds this court. O'Brien's speculation does not. Whatever pervasive value a state court decision may have, it cannot override the Supremacy Clause or controlling federal precedent. Under Article 6, the hierarchy is clear. Congress speaks through statute, the Supreme Court interprets, and this court enforces. State disagreement is not binding authority. It cannot override federal supremacy. So let me skip ahead here a little bit, guys. But you can see that there is a pretty definitive breakdown here, and I encourage you guys to read it. I'm trying to see, I think that there was another section that I wanted to read down here. It's really long. Hold on, I think I need to go from the other direction, yeah. Here we go. Let me read the conclusion for you guys. Conclusion. The record leaves no doubt. The law leaves no room. The balance of harm leaves no question. The public interest is not close. What remains is the court's duty. That duty is clear. The Constitution is not a suggestion. It is a covenant. Its promises are not advisory. They are law. This case concerns one of those promises, that federal law governs within Indian country, that sovereignty once recognized cannot be taken without Congress, and that treaties solemnly ratified mean tomorrow what they meant yesterday. The record tells a tale of two cities. One chose partnership. The other declined that same cooperative framework. In Coweta, cooperation produced clarity, safety, and shared purpose. In Henrietta, refusal produced confusion and the exercise of authority the Constitution does not permit. The difference is not geography, resources, or necessity. It is obedience to law. The City of Henrietta asked this court to recognize authority Congress never granted, grounded in a state court decision that cannot override federal law, and to extend a recent Supreme Court decision beyond the limits that court imposed. The nation asked only that the Constitution be enforced. That is the only request this court can grant. This injunction draws no new line. It enforces the one Congress already drew. It is therefore ordered that plaintiff Muscogee Creek Nation's motion for preliminary injunction is granted. It is further ordered that the City of Henryetta, Oklahoma, and all its officers, agents, and employees are enjoined from initiating, pursuing, or enforcing any municipal criminal prosecution or citation against any Indian, whether or not a member of the Muscogee Creek Nation, for conduct occurring within the boundaries of the Muscogee Creek Reservation until further order of this court. This injunction applies to prosecutions both under both state and municipal ordinances, including traffic, misdemeanor, and code violations. Nothing in this order precludes Henryetta from entering or executing a lawful cross-deputization agreement with the Muscogee Creek Nation or from cooperating in investigations consistent with federal and tribal law. The court retains jurisdiction to monitor compliance and to modify this injunction as justice requires. So that's it, guys. And there's more in there, so I encourage you guys to read it, and also the original complaint too, because that's also gives a lot of background on what happened. I don't know what happened early in the stream with it going down. It looks like it's okay now. So, and then, like I said yesterday, on Monday, I think we're going to shoot for probably 6 o'clock. On Monday, we're going to do a live stream and talk about the constitutional amendments that are going to be on the ballot for the May 30th special election, and just kind of go over them and show you guys where you can get the information to read the amendments on the sample ballot ahead of time. And then we'll also have the guys from Decolonize Decatur on again sometime. We get it rescheduled. And also we're probably going to have Russell Cobb to come on to talk about the tour that he's going to be giving. And I think that's it. So thanks for tuning in, guys. I appreciate you watching us, and we'll see you again next time. Mado Hadam Chihichat Lees.